Let's get started, bro. Sorry it took so long, everybody. Welcome to the fourth episode of Dark Academia with your hosts, Rich and Paul. This is Second Amendment, Histories and Controversies. Basically, what we want to do here with this show is bring some of let me take these headbuds off. I don't think I need them. Basically, bring some of our background and quote-unquote formal education, quote-unquote formal credentialism to this sphere. I think most academics suck because they get chosen to be academics for a certain reason, and it's not because they have transgressive ideas or push against the status quo in any way, and that's sort of what we want to do. We don't want to do a show that was about, current events. Everyone has a current event show. Not that it isn't necessary. Not that it, isn't good and entertaining. But it's we want to do something a little different. So the phone should be, it's like on a stack right up to the mic, so it should be good.
Yeah, can everyone still hear me?
Everyone's
I switched to my headphones, so can I get a thumbs up that I'm still good?
Anybody still here? Hearing them okay? Everyone says Paul.
To change a little bit.
Everyone says Paul sounds good. Okay.
Okay, perfect.
All right, so that's the idea of the show, kind of the impetus of it. Let you know where we're coming from. Both of us, liberal arts undergrad degrees, law degrees, past the bar, have basically some divergent views from what you'll get in the mainstream. The topic of firearms has been covered very widely. It's a very popular topic. A lot of people like guns. A lot of people who are into guns consider themselves some sort of de facto renegades, maybe kind of the remnants of earlier patriots in America, maybe a more wilder European stock, even though many don't see that explicitly. It's implicitly viewed that way, and the enemies of our civilization frankly hate it. All the people that are in favor of all the things we dislike are also adamant gun control advocates. And, there's like the term gun stock for old stock Canadians, the white Canadians. You get the derision from heads of state in the U.S., Obama talking about Americans clinging to their guns and Bibles and that sort of thing. And so you get this sense that these people, for whatever reason, are very bothered by the idea of a legacy American or a legacy Canadian with the rifle, right? Particularly a rifle. Handguns are one thing. The rifles are almost a whole other thing. So we're going to talk in this show a little bit about... So Paul's going to introduce some ideas about the early reasoning for the Second Amendment, going back to Revolutionary era. He's going to talk a little bit about purposes, some things you might not get everywhere else. We're going to run through the federal law history that started in 1934 with Roosevelt, who was a 4-term president, very, very close to and what would you say, kind of like a international liberal dictator, if there ever was one?
Yeah, I mean, it's never really talked about with his 4 terms, but it was thoroughly un-American.
It was.
I know they used the war as a reasoning, but and I know Vietnam is technically different, but you had commanders and chiefs come and go during that, but
he stuck around for a long time, man.
Yeah.
He was around for a long time, and unsurprisingly, this guy who wanted to expand on Wilson internationalism and Wilsonian liberalism and spread liberal democracy, it's kind of no surprise that this guy, who was a 4-term president, the only one in history, would be where we first got our kind of original federal gun control law. So we'll run through those. We'll kind of contrast some modern views and even the federal Second Amendment with state Second Amendments. Paul will do a rundown on that. What you'll find is that where liberal legal scholars and academics criticized the federal Second Amendment, that a lot of states that became states after the ratification of the Second Amendment in 1791 basically went further and they were more explicit. And you can really look to state constitutions. All but maybe 6 or 8 state constitutions have something about firearms in there. And many of them are very explicit. Paul will go through some of those. We'll hit on red flag laws briefly. I say briefly because I hit on it in the show, the First Amendment show, where I think that red flag laws violate, a litany of rights. But it's really a free speech thing. But then, of course, it's going to be a Second Amendment thing, because even if you maybe didn't have the right to say something, let's just suspend that for a minute, kind of suspend some disbelief, and say that you were saying crazy stuff that maybe you shouldn't have been saying. Again, I think you should be able to say it. Suspend that for a minute. Can they still come take your guns? Like, don't you still have a right to keep and bear arms regardless of what you're saying? And then that, if they criminalize what you're saying, does that rise to the level of a federal or state disability? We'll talk about disabilities a little bit. I guess just real briefly on getting rights back. What do you think, Paul? Just to hit on it, just to let people know what's out there, like general stuff.
Yeah, I mean, just a little.
If you want to pull up like one of those outlines, go ahead. And I've forgotten to pull mine up, so if you can find yours, pull that up.
We can hit it at another time.
We'll run through Heller versus DC, which is the most recent Supreme Court. Well, it's not the most recent. It's of the recent era of the Supreme Court taking a Second Amendment case up, and there was a lot of debates about the various clauses. There was debates about where the comma was placed in the Second Amendment. We'll talk about that. We'll hit on McDonald versus Chicago, which was basically just made Heller versus DC apply to states. I guess we can maybe hit on some things about constitutional carry, pros and cons. We can hit on the self-defense, Castle Doctrine, and maybe stand your ground versus duty to retreat, and how those kind of interplay. Oh, this guy named Israel Cool's in the chat says
he said 4 of them.
Yeah, it's very interesting. Hey, Midgard, nice to see you. These people, just real quick, they posted something about me having certain views that I have, and I don't disavow my German ancestors from really any period of Germany, and that bothers them. These people will hail Bibi Netanyahu as a saint who bombed his way through what was then Palestine to create settlements. They still do the same thing, and people think they're heroes. It's crazy. So let's. Where do you want to get started on that? Some of the early history purposes of your theories of the purpose of Second Amendments coming out of, maybe. I guess we're jumping into this. I'll kind of just start with a couple opening thoughts and throw it to you.
Yeah.
It wasn't uncommon for people to have firearms everywhere. They were these Europeans coming over and taming a very difficult continent. It was vast. There was all kinds of animals. At times there was conflict with various Indian tribes. It's a dangerous place. It was a very dangerous place. There was a lot of people who didn't make it through winters. You were really out there on your own. You didn't have, a nice, cozy police department you could go run to. There wasn't a lot necessarily. There wasn't necessarily a lot of infrastructure. It was sort of, for a long time, these people who again came from Europe and were just out there trying to make it the best way they could. And it was very difficult. Like I said, a lot of people passed away. A lot of people were involved in Indian attacks. A lot of people were abducted in Indian attacks. A lot of people were killed. People killed by wild animals. People died from starvation. You had this really rough continent. And it was an era when, there was entire civilizations all throughout Europe, and people were going to something and kind of starting over. So it would almost be like getting thrown back in time a couple hundred years in many ways. So you're going to have tools, you're going to have axes, you're going to have rifles, you're going to have shovels. And the rifle was really a tool, and it, later became sort of fortified in various epochs in history. The Revolutionary War, of course, then the Wild West, where it was yes still a tool, but it was like the tool. And there's a famous Charlton Heston speech about it's the cold dead hand speech. But the interesting part of that speech is really the early stuff, not the pry this from my cold dead hands, Mr. Gore. It's the early stuff where he talks about how you have these simple materials. You have wood and gunpowder and steel, and you're able to hand these simple earthen materials to essentially a peasant and give them the power to stand up to kings, to stand up to imperial guards, to stand up to whoever. And that it sort of you can't push the hunter, you can't push the peasant around the same anymore when he puts these simple materials together and makes this special stuff, as Heston called it at the NRA speech. So that's some of my take on the early, where we're coming from and where things are going forward. So with that, I'll turn it over to my co-host.
Yeah, that's very interesting too about the peasants, because sword play, which was the traditional defense back then, takes a little more skill. It takes much less skill to use a firearm. But I teased this earlier in the week on Twitter, if anyone saw, but I had about 4 basic reasons why the Second Amendment was put into place in 1791. What the classical liberal mindset is behind this idea. And the first one, Rich was very right, that I have is hunting. And hunting is life-sustaining for food and, clothing and all other animal parts. Today it's devolved into something else, and I'm not a huge fan of recreational hunting, but, it comes from this history of sustenance hunting. But also even further, hunting, and like Rich mentioned, you have hunting protection. You're out hunting a deer or a rabbit. Even if you were hunting with like a trap, you take your rifle with you in case you run into a bear or a wolf, because they were much more common than they are today in the United States.
Yeah, they're everywhere.
Yeah. And so, or just to protect the homestead from those things. The bear comes to your frontier home, you need it. And so hunting, and I know hunting is thrown around a lot today by the conservatives and the NRA and the Second Amendment people.
And the anti-Second Amendment, they think, why do you need an AK-47 to hunt deer? Like, they take it too far.
Yes. And, okay, I will give a little and say, okay, maybe you don't need an AK-47 to hunt a deer, but you can.
But you need it to hunt the dangerous game, the most dangerous game.
Yeah. And then so the second reason I had, besides hunting, that this is in the back of the people's mind when they're passing this amendment, why you want guns or firearms, is personal protection. And they're like, well, you can personally protect yourself with a musket. That's the argument today. Something's better than nothing. And this isn't just personal protection from people coming in. This is, again, homestead protection. This is, Indians or, other...
miscreants.
Just whoever's out there trying to get in your home. One shot is better than no shots. I think we can all agree on that. And, again, this is very much tied to the rifle, too, because pistols were aristocratic, because they were much more expensive, at least in the 1790s. But still, even your everyday, flintlock that you'd be using in 1791, better than nothing. Number 3 I had was the one that the left likes to hit on, where the Second Amendment says a well-regulated militia. And military service was absolutely a part of this amendment. I don't know if people know, but in the Constitution, the Congress in Article 1 is allowed to create a Navy. That's like a mandate of them. They're allowed to spend and create a Navy, and that's indefinite. But technically, the military, a standing military, and we'll see some in the state constitutions, a standing military was very looked down upon because we didn't want to be a military power. We didn't want to have that hassle or to have that look in the world. So in the Constitution, it says that the military budget basically has to be reapportioned every 2 years. And that was to encourage you fight your fight and then they go home. Now they just re-up it every 2 years and we have the perpetual military that we have now. So because of the unpermanence of the military, no standing army, militia service was much more important. And you had states getting called up to go fight whoever. You know, the Revolutionary War had a standing army, or had a army, the Revolutionary Army led by Washington, but there was also state militias that were out fighting. Later on, after that, in some of the Indian Wars, or like the War of 1812, they called up state militias, where, you know, they come in and everyone has to do 6 months, 8 months, whatever it is. You fight your fight, and then you go home. And because it was a militia and nothing funded by the government, it was encouraged and necessary for you to have a rifle at home that you would then take with you to do your military service.
And it was this idea that everybody, you know, is a part of this. So
Yes.
it's sort of like there was no official necessarily militia to necessarily be in. And, you know, the idea of well-regulated and working order was basically things were in working order. It was viewed, this the militia clause. I think the important thing is that for most of up until 1934 in U.S. history, people just assumed it was kind of taken for granted. People didn't read the militia clause and say, "Oh, you can't have federally you're prohibited from owning a firearm unless you're in a militia." They're like, "No, this is just the common people or the militia. This is how it's understood."
Yeah, absolutely.
And what do you think about? Why don't you for this segment we'll kind of wrap it up with your thoughts on just the general idea of having firearms as a quasi-political solution to a government that is basically going farther than prescribed than what they should be doing.
And then that was my fourth and final point, is that it was very much understood by all the founders and all the classical liberals at the time that firearms were meant as protection from government. The Revolution is a great example of that, where we had guns, they had guns, and we fought it out. But even further than that, you had people like Jefferson who thought a revolution was healthy for a society. Like, we need to just have a revolution every once in a while, and a new constitution every, generation or two. So the idea that the reason we kept, or that the founders wanted you to have your guns is because one of the first things that the English did was take the guns and powder stores. The battle of Lexington and Concord, shot heard around the world, the first battle of the Revolution, is the British were marching to those places to confiscate and seize the colonials' powder stores. So it's shown that tyrannical governments, the first thing they want to do is disarm a citizenry. And then the founders knew, and the classical liberals knew, that an armed citizenry is the way you push back. A great example of this that I had that's more modern is the Bundy standoff.
Oh, yeah.
Where the federal government was like, you need to stop grazing your cattle on our land. And he was like, this is the simplified thing. And he was like, this is my land, or this is public land, it doesn't matter. And they started coming in, seizing his cows. And he got a bunch of buddies together. They had guns, and they said, you're not going to take our cows. And it lasted about a month. And at the end of the day, because the argument was, well, you just let them do it and let the courts take them. And he's like, no, I want my cows now, and all that stuff. And so the armed protesters stopped them. Some people were arrested, but when it did end up going through the courts, he was in the right, and they didn't take his cows. Like, it's a understood way of how the government can't come after you because they know that there's consequences too.
And I think it scares them.
And that was intended.
Yeah, I think there's
not even in a malicious way. Not like in a scary malicious way. It's just a matter of fact, like, you have guns and we know you have guns.
It's like that Schulzenstein quote where he's talking about how we burned in the camps wishing we would have done something. You know, if every time one of the communists would have come to arrest them and take them to the camps, that they might have not made it home, how different things might have gone. And it's that idea, you know? It's this idea that you to really respect a people or a person or a group of people, there's an element of fear there. And if they think, yeah, let's go do XYZ abuse to people, and they think, you know what, we might not make it home, like, that changes the dynamic a lot.
Absolutely.
It just is what it is, you know? People might not like it. It's human nature. It is what it is. I have a chat let me address real quick. Somebody asked about a relief from disability before they changed the prohibited persons standards. So, and then he asked if you got a relief from a court on what was prohibited, you should definitely be able to own and get your concealed license. So if you want, message me directly on Telegram. If you don't know what my Telegram is, just ask in the chat. I'll send it to you. But yeah, if you got a relief from the disability, you should be able to go ahead. Ohio is one of the better states in being able to cure disabilities. We have a statutory provision to do it. Other places kind of have to go directly through the court or they can't even do it at all. But there's statutory enactment specifically for people curing disabilities to go through the court and then be able to, purchase, possess. You might have to do something as far as the CCW, or that should be okay. Sometimes you have to send a letter with the court granting you the relief from the disability to the FBI that manages the NIC system, so that you don't get flagged when you go to buy.
They give you a number.
You'll get a number. So, I think that you're in a good state if you're in Ohio for that. But if you need more information, just shoot me an email, like off public. It's the Telegram handle's the same as my Twitter. So just shoot me a message off of a public, not in public, and I'll look through that for you.
And just to wrap this up, this little portion up, I'm going to post in the chat so people can look at all of them. This is the state constitution's protections. And if you read some of them, you can see where the mindset truly was at. One that I want to highlight is Vermont, which would have been the 14th state admitted the Union in 1791. Their Second Amendment says that the people have a right to bear arms for the defense of themselves and the state, and as standing armies in times of peace are dangerous to liberty, they ought not be kept up, and that the military should be kept under strict subordination to and governed by the civil power. So, very clear. That is much more clear to the mindset. I don't know why they decided to be vague in the Constitution. Maybe they just thought people knew what they meant, and that has gone away.
I think they did. I think it was widely accepted and understood for a long time, and then it got kind of, these people who are anti-gun kind of threw monkey wrenches in the place. I think if you look
Yeah.
at the Ohio, it's very clear. When did Ohio become a state? It was after that, obviously, but
1820, something like that.
all right. So we're a little bit after ratification of the Second Amendment at this point, and the Article 1, Section 4, first clause. So the people have the right to bear arms for their defense and security. It's the first clause, man. You get a hard semicolon after that. Like, it's I think it's pretty obvious, and it says Supreme Court of Ohio held this position to mean secure to every person a fundamental individual right to bear arms for their defense and security. And I think that is broad, to the point of, like, you should, anywhere you are and about, where you happen to be, where you have an interest in defense or security, you should be able to own firearms. I think that's pretty clear.
Yeah, if you go and look at all of those states, basically all of the states that have the Second Amendment type thing in their constitution make it very specific that it's defense of self. I mean, Delaware's constitution, so Delaware would have been an original state, says a person has the right to keep and bear arms for the defense of self, family, home, and state, and for hunting and recreational uses.
Yeah, so that's really broad.
Everything.
Very broad.
You're allowed to have a gun to go to the shooting range. Just to look at it, you're allowed to have it. That's
defense of self and family, defense of your house. Like, the house also, the defense of your house is really interesting, because that brings up the implication that lethal force was acceptable in defense of property, Yeah. This whole, like, people can be replaced, property can't, that we've been seeing, that we saw all summer long last summer. That, kind of flies in the face of some of these state constitutions that say, hold on, no, yeah, you can defend your house. And it's important to note that it kind of seems you're a coward. This person. Oh wait, hold on. I was going to reply. They said they're making a Wikipedia page for me. That's cool. I don't know why you think I'm a coward. I'm not hiding behind Palestinian rights. I don't care all that much for Palestinians. I dislike international Jewry and their machinations. I've made that very clear for years. For years, I've made it clear I don't like you people. You're freaks. You constantly come at me. You're bizarre weirdos. You have a weird obsession. You mutilate children. You traffic children. I don't want anything to do with you people. You're frankly, you rabid Zionists are an abomination. That's what I have to say about you. There's nothing cowardly there. Here I am, my real face, telling you how I feel. I don't know what else you want from me. So anyway, as we're going, the state constitutions make this clear, and it's important to note in constitutional theory is that the federal constitution provides basically the what do they call it? The floor of the rights? Is it the floor?
Yes.
So the federal constitution is the floor. This is your absolute, like, bare bones minimum rights. States were free to grant their citizens more rights than what the federal constitution did, and they often did. And that's widely recognized that the federal constitution is the bare bones floor. And if state wants to go further than that, they are more than welcome to. So that's an important theory that is very prevalent in constitutional history, theory, interpretation, that what the state says. Now, so people kind of confuse this stuff because they think, like, a federal preemption means the federal constitution will win. That's a different concept. Like, preemption of laws is a different concept. What it is important for this particular thing in this kind of capsule we're talking about is to know that when it comes to constitutions, federal is the floor, state can set a higher level of rights. Okay, so
yeah.
let's run through. Let me run through. So yeah, that's kind of our background. Now you know about the state constitutions. A lot of states are now adopting a constitutional carry. Basically, you're meaning that they interpreted their state constitution, like the Ohio one and the other ones we read, that if it says you are able to keep and bear arms for individual purposes, for your safety and defense and security, that necessarily means outside the house. It necessarily means wherever you happen to be. And especially states that list, individual, family, home as sort of three separate entities requiring protection. That makes it pretty clear that they're not just saying you can have a gun in your house to protect the lives of your family when they're home. It's obviously more than that. In some states that have, I think, like I said, about a dozen or so now, have a constitutional carry where if you are not prohibited from having a gun, you can go ahead and carry. So, and that's the theory of where that comes from. Let me run through some of the federal law. So this is important, really two reasons. One is it comes up in Heller versus DC, Supreme Court case. Scalia wrote a line in there, wrote a couple lines that were, I think, problematic. Basically, Scalia had the opportunity to go ham, take the Second Amendment as far as he wanted to, and he didn't. He didn't even get close. He essentially said that, hey, there's a long history of the federal government regulating firearms and different types of firearms, and we should respect that. Well, the issue with that is the long history started in 1934 with Roosevelt, as we were discussing a little earlier. The first thing you get is the National Firearms Act in 34. And it was, so from 1791 to 1934, you basically get dead silence from federal legislature, right? Nothing.
Yeah.
They're not coming for it all. They're just kind of letting it go. So what happens is there was a lot of people blame the Roaring '20s and the violence that exploded around Prohibition. The St. Valentine's Day Massacre happened. Somebody tried to assassinate FDR. So they came about with the 1934 Federal Firearms Act. It did a few things. One of the things was the infamous $200 tax stamp. At the time, in 1934, a Thompson machine gun was $200. So what they did, in essence, was say that these machine guns, suppressors, short-barreled rifles, that sort of thing, were going to have a tax on them of $200. Again, $200 at the time was the cost of the Thompson machine gun and similar weapons. It was essentially 100% tax on whatever you're buying. So, imagine if they were to do something like this now, it would be, you go buy your AR-15. Let's say the average AR-15 is $1,500, and you have to pay a $1,500 stamp to get one. That's what was going on. Actually, the equivalent, it was close to, if you do it in today's money, it was close to $4,000, adjusted for inflation, the $200 rifles. So, the Valentine's Day Massacre, the attempt on FDR's life, all of the gang violence they've seen, they said, hold on, we got to do something to get this under control. So they put certain weapons on the registry, made them class 3, and made it, the important thing about the registry was, one, whoa, holy cow, we now have a firearms registry, and it makes transfers of those difficult. It makes it a crime to transfer them improperly. So if I have a class 3 weapon, if I have a short-barreled rifle, suppressor, machine gun, I can't just go sell it to somebody. I have to transfer that license and let the government know about it, and then that next person has to pay a fee. That's wildly divergent from how NFA items are transferred. So if I bought a pistol one time. I didn't really like it. Had a family member that liked it. My family member is allowed to buy firearms. They have no felonies. They're not a prohibited person in any way. I'm able to just sell that to them. We don't have to do any paperwork. The government doesn't know about anything. I can just sell it off to them. No problem. If you do something like that with a NFA item, it's a felony. Big trouble. Big trouble. You can't even accidentally do it. These are strict liability crimes. Normally, you have to have a mens rea, a guilty mind. You had to intend to do the crime, right? Not the case. You can basically accidentally do it. You can't say, oh, I didn't know it was an NFA item. You can't say, oh, I didn't know I couldn't attach this rifle lower to this pistol upper. It was a mistake. I was drinking and I thought it was my 16-inch upper and it was really my 12.5-inch upper, and I accidentally manufactured a short-barreled rifle. My bad. They're going to say, hey, sorry, buddy. This is strict liability. You're effed. Okay, that's the National Firearms Act in a nutshell. Next big thing that came about wasn't until 1968, the Gun Control Act. I think that was Emanuel Seller. Did Emanuel Seller introduce that one? Oh, he did one of these. Schumer did one, Feinstein did one, Seller did one. So, similarly to kind of if you want to view, and I do view the NFA as a backlash to the Roaring 20s, I think the Gun Control Act of 1968 was a federal backlash, if you will, to the violence and civil unrest throughout the 1960s. You had a JFK assassination, you had an MLK assassination, you had a Robert Kennedy assassination, you had race riots, you had integration riots, busing riots. Thing was falling apart. I know a guy that was serving in Vietnam, and he got offered to leave Vietnam early, right then and there. We'll send you home tomorrow if you agree to be a police officer where you were back home for 4 years. He declined, finished out his tour in Vietnam, and said, I think it's safer up here along the DMZ. I mean, this is just kind of give you, if you weren't there, I wasn't there, but some of the stories I've gotten from people who were there, it was pretty wild. So what did Gun Control Act do? A couple things. Let's take a look here. Let me pull up my notes. It established the prohibited persons. It established who this list of prohibited persons, and it's that. And it also did established the FFL requirements for those in the firearm industry. So you start to see a regulation of. Oh yeah, this one was Emanuel Sellers. So you start to see the regulation of the industry. There was a ban on mail order weapons, so you couldn't order them from the catalog anymore. And then let's see what else happened here. Yeah, so you get the prohibited persons. That's the form.
The background check.
Yeah, that's the beginning of what becomes the background check. This established the prohibited persons. If you're a fugitive from justice, you're an addict to controlled substance. What's the form name that's on? Is it a 9? What's the name of that form? The paper you actually.
Yeah.
Can't remember the name of it off the top of my head. But that's the form when you go to buy a firearm that you fill out. The prohibited person stuff, all those questions, if you've ever been dishonorably discharged, if you've ever renounced your U.S. citizenship, convicted of a felony or domestic violence, which is the Lautenberg Amendment, that sort of thing. So that established that, and it didn't really have any teeth at the time. So although it existed, the background checks weren't mandatory until you get Brady Handgun Violence Protection Act. That one was put through by Chuck Schumer. So that established the NICS system, the National Instant Criminal Background Check System, maintained by the FBI. So the idea is that if you're a prohibited person, you're going to show up somewhere in this NICS system. If you've been dishonorably discharged, if you have one of these prohibitive, you have it's called a disability, some sort of firearm disability. It'll flag you, and that's it. The gun store, if they sell you the gun anyway, will be held liable. Very harsh criminal penalties, like a $10,000 fine, and 10 years in prison, or the max sentences. So you get that. So now we have, from 1968, a list of people who can't have guns for various reasons. And then it was, like I said, mostly toothless. It existed, but it was not a whole lot was going on with it until the Brady Handgun Violence Prevention Act gets put through in the 90s. You also get the assault weapon ban as part of the omnibus bill at this time too. Have to mention, although it's important in its own right. So 1986, the Firearm Owners Protection Act, kind of Ronald Reagan sort of spearheaded this, along with, I think the NRA wanted it. What was going on is that the ATF was sort of getting out of control with this FFL inspections. As a political machine, they were using, how would you describe it, Paul? It's like they were being malicious. They were able to go in and inspect gun stores, but they were doing it constantly to the point where people were like, I have to like hire another dude to help customers because I'm always talking to the ATF. So,
yeah, they could just like surprise inspection.
And they were doing it a lot. It was becoming a problem in the industry. Gun stores were complaining. And then gun lobbies began to put some pressure on Congress and ask them.
The rule puts in a once per year thing.
Yeah, so now it says, the ATF, you can come in once per year and inspect us. You can't come back every week and inspect us, or every day and inspect us and harass us like this. Here's why this is, that it would, if that was all the federal, it's called FOPA, Federal Owners Protection Act. There's all kinds of acronyms in law, like environmental law has literally pages of them. There's hundreds of acronyms. Everything has a funny acronym. So, and they throw them around like you're supposed to know. So they'll be like, yeah, FOPA, the GCA, all this stuff. And you're like, I just learned this law 2 minutes ago. What are you saying? So the what happened with the Firearm Owners Protection Act? It was going to rein in the ATF a bit, and then as kind of a last minute negotiation, I guess you could say, was thrown in. There was an amendment thrown in, and it was the ban on new automatic firearms to civilians. So once that was it's 18 USC 922. So sometimes you see 922 come up, I think, with some like import rifles and whatnot. What that did was then immediately make the price of automatic weapons skyrocket. Automatic weapons you were already able to buy. They were an NFA weapon, right, since 1934, and you had the tax stamp, but they were still available for manufacture. If you have ever bought a suppressor, it's like that. So you can go buy a suppressor today. You pay the tax stamp. They're relatively easy to get. They're relatively inexpensive, right? Same thing with select fire, burst fire, automatic weapons prior to this happening in 1986. They were just available. You could buy them. They were a little more expensive maybe than standard, but you pay the tax, you get it. But now, all the ones that were currently on the market, that was it. There was not going to be any more introduced. So that, of course, shot the price up to an outrageous degree, to where you're seeing, old Vietnam era musket beat the hell automatic rifles going for $20,000 and MP5s going for $20,000 or more, and that's what did this. And it was kind of inserted. And like I said, kind of an 11th hour thing. The Democrats were saying, if you don't let us put this in, we're not going to pass the Firearm Owner Protection Act. From what I've heard, the Republicans didn't want it, but they thought we can get this repealed later, and it didn't happen. To not beat up on them too much, there's been a lot of like the concealed carry and concealed handgun license that have been passed in various states that had a lot of these sort of poison pills in them. Where Democrats put them in as a compromise, hoping to torpedo the bill, and then it got pushed through anyway. and then through legislation or lawsuits later, a lot of these poison pills kind of got taken out. So it wasn't an absurd strategy. It's a political slash legal strategy that works, that has a history, that works to this day, really, in some cases, where some of these amendments get tossed later and struck down or revised. It just didn't happen in that case. There's a Gun Free School Zone Act. Herb Cole of Wisconsin. Several of these people, if you noticed, are of the Semitic race. That this thing got. This was part of the Crime Control Act of 1990. This had a weird thing with. This is a famous law and then subsequent case, which is the Lopez case. And what's interesting about it is that it was, I think the Gun Free School Zone Act thing was absurd. It made it like real hard for people who should be having guns to get a gun in a school zone, made the penalties really harsh. But what happened that came out of it 5 years later was U.S. versus Lopez, which really reined in the Commerce Clause. So it kind of ended up being a neat thing in the sense that I think that this Herbert Cole had not great intentions to begin with, and then it ended up getting basically part of it struck down and the Commerce Clause getting reined in because he kind of went too far. So it's just an interesting bit of legal history, and that's really the whole history of federal gun laws. You have like five big laws. You have National Firearms Act, Gun Control Act, Brady, Firearm Owner Protection Act, Gun Free School Zone Act. You have five big things, and like the NFA, that stuff, those violations, a lot of the federal things that were alleged at Ruby Ridge, for example, that was the short barrel shotgun or rifle issue.
It was a short barrel shotgun.
Short barrel shotgun. That was the auspices to go do the raid was from the 1934 Act. So a lot of the law surrounding Waco was also similar. The official reports alleged basically that because there was some on the site of where the Branch Davidians lived, there were some lathes and steel, different steelworking materials that they could have potentially manufactured or modified weapons illegally, which would have been a violation of 1934 NFA. Therefore, the warrant and the subsequent actions were justified. So, they're going back. This 1934 Act has proven to be deadly to American citizens a couple of times. Those two very famously. The like I said, under the auspices of the 34 Act and what could be, what was the sale of a short-barreled shotgun and what could be the potential manufacturing. Let me tell you what's really scary about that potential manufacturing thing in Waco. If you own any sort of machine, any sort of like CNC machine, and you could potentially make a little drop-in auto sear, or if you have a AR-15 rifle lower and a pistol lower and two pistol uppers, two short barrel uppers, there's like a presumption that if you have an upper that's a short upper that doesn't have a matching pistol lower, that you might be in the business of manufacturing a short-barreled rifle. Man, and that's scary, because like how many people have some sort of lathe or CNC machine, or maybe an extra upper laying around, or or maybe they put the brace on the wrong thing, like the example that I used earlier, the guy's trying out different parts and he's having a couple beers and I accidentally put my 14-inch upper on my rifle lower, not the pistol lower that had the SB3 brace. Like, and you're like, now you just committed a felony where you could
Well,
potentially be put in prison for 10 years.
and that's one of the ways too where the the stings come in, because like you're sitting there with an undercover guy, and he sees your collection, and he's like, "Oh, let's put that together, put that and that together. I want to see it. It looks cool." And that's all you need.
Yeah. Somebody would say, yeah, how would this look? You think, how would this look? And then committed a felony, committed a big felony, committed a
Yeah.
National Firearms Act violation, carries a $10,000 fine and 10-year prison stay, potentially. That's pretty scary. So, hit the federal stuff, constitutional stuff. Let me just hit Heller and McDonald real quick. Do you have anything else, Paul, you want to add to all that stuff we just...
No.
Okay, you said you got just a little bit left. Let's run through some of this.
I apologize. I think Rich is going to stay on. I had some very poor planning today.
Well, part of it was my technological...
And then the boomer...
Technological society and its consequences has been a disaster for our timing tonight. Okay, let me just hit Heller versus DC. Heller.
Yeah.
So DC, there was a law that made it difficult to get a permit to have a firearm in your house. Okay, guy challenged it. He said, "Hang on a second, I have the right to keep and bear arms." Goes up to the Supreme Court. Supreme Court says, "Yeah, actually you do." This is the one I was talking about where I think Scalia kind of waffled a bit. He says, "Yeah, you actually do have the right to keep and bear arms." And then the militia clause gets argued, and they said, looking at this militia stuff and what was going on in the country when this was created and the history of the federal laws, we don't think you need to actually be in a militia. We think that the Second Amendment federally applies to the individual right, not just as a part of some broader, more formal militia, like that the individual is sort of the militia. So this is important for a couple reasons, because it means that if you are in a state or jurisdiction, this was in DC, the District of Columbia, that decides they're going to pass a law that says you can't, you have to have a license to have a firearm in your house, and you're otherwise not a prohibited person. This means that those laws are not constitutional anymore. Huge. First case really of its kind where the Supreme Court visited something relating to the Second Amendment. Very important. A similar issue, let's see, similar issue came up in Chicago versus McDonald a couple years later. And the question for the Supreme Court was, does that decision apply to all the states? I guess that was the federal government because it was DC, but what they said was yes. This through the 14th Amendment. What's that called?
The due process clause.
Yeah, no, not that part. What's the name?
It's
I blanked on it.
Yeah, so did I. You made me do it.
I asked you too fast. Yeah, so through the due process clause, it's
and it's applied to the state.
Yeah, but what's the term? What's the legalese term?
Sorry, it's incorporated.
Incorporated, yes, and that's the legalese term. So they incorporated the Second Amendment, meaning it now applies to the states, which, as we talked about in the First Amendment show a couple weeks back, everything in the First Amendment's been fully incorporated. So although the federal Constitution applies to the federal government doing stuff, if it's been incorporated through the 14th Amendment, that means it now also applies to the states. The states can't deprive you of that right. So this is important because there are a lot of cases out there, and there might even be some people in prison and there might even be some cases where people, different police and jurisdictions and prosecutors basically presumed that the possession of a firearm without a license in the house or anywhere was a crime in and of itself. Um, and McDonald versus Chicago, incorporating Heller versus DC, really kind of upended that and turned it on its head. It was a good thing. I think. I mean, I think they were both good cases, even though Scalia didn't go far enough. What do you think?
Yeah, the biggest problem with that Scalia did in that case is he because he was going off of recent history, he left his roots as an originalist. He just went with basically modern American history. He was like, the government has a history of regulating firearm usage, so some is okay. When he really had the opportunity to say, actually, we've never done this.
Yeah.
And so that's really his problem. So it's looked at as a win by conservatives and gun right advocates as a big win that this helps our rights, but it's looked at through a lens of kind of forgetting our firearm roots and looking at it through a 1934, 38 lens.
Yeah. Yeah, I think so. I think it was almost like pretending history started in the 20th century, which is a problem a lot of people have in a lot of issues, frankly,
Yeah, it was a big. He missed a huge opportunity, and you can't get a Scalia fan to admit it, but it's a real poor look for somebody who claims to look at the original intention of the Constitution to find out what we should apply now. It was a huge failing of his entire doctrine of.
Yeah, his own constitutional theory was undermined by him saying, "Well, I'm going to go with this FDR thing." Like FDR wasn't an originalist. FDR and Wilson did whatever they wanted.
Yeah.
They didn't care. So, all right, how much time do you have left?
About 10 minutes. I can
all right.
run Ruby Ridge probably.
We can wrap. Oh, I think we hit basically the important legal things of Waco and Ruby Ridge. But why don't you share a couple of the facts that you like, a couple of the interesting facts that you came across? Since I hit the kind of the legal issues and the kind of frightening aspect of.
I mean, so there's the short barrel shotgun he sold to an informant. We mentioned that. And that obviously triggers the 10 years, $10,000 fine. And they tried to get him to flip. He had visited a couple of meetings with, like, the Aryan Nation or something like that. But he's really, in the looks of it, he's really kind of a poster boy for who the feds aren't going to like. He lives in the woods by himself. He homeschools his kids. He
kind of has some anti-government sentiments, which is fair given all this.
Yeah, anti-government. Some race realism ideas. And so they tried to get him to flip, and he wouldn't. And so then they served him with this warrant. And they, interestingly enough, the Be Wary people out there, they didn't want to go to his house when the arrest warrant was issued because they were worried about what might happen. So they tricked him. They acted like a stranded car on the side of the road, and him and his wife stopped to help them like a good citizen, and they arrested him. And then the real problem starts. They sent him like 3 different court dates to appear to, and so he didn't show up to 1 or 2, and then they were gonna go get him, and then they were like, well, we'll give him to the last date. If he doesn't show up, then we'll go. And then like the ATF gets involved. And then they start, they're like, we're just going. We're going to serve this warrant and arrest him. It's a mess. And here comes back to protection on 2 levels. They sent out like a recon unit to his home. His son, him, and one of the son's friends or his friends were out in the woods. The dog hears something. These recon guys out there in full camo and night vision goggles. The dog comes out of the woods. The agents shoot the dog, and I don't know what normal people would think. But somebody just shot my dog. I'm gonna, I'm defending myself, and then that's where the gunfight ensues. Yeah, I mean that's some of the real, uh, you know, horrible things that happened. They changed the rules of engagement, um, which is interesting because it was like once they had been like they have these strict rules of how we deal with people, but like once they had been threatened, like the tyrannical government had been threatened, the rules just magically changed, and that's how his wife ends up getting killed because they were just like, if you see anyone, you have a shoot to kill order, just green light. And so that's the sniper. I don't know if a lot of people know, the one that killed Vicky. He was aiming at Randy in the back. He even says in his affidavit, the sniper says, "I put my crosshairs on his spine," and then he moved. But his wife was killed holding their baby. By the way, was shot through a door. So the sniper ignored all gun safety of like know where your round's gonna travel. There was just a lot wrong with when it happened, and I don't know what they totally expect. This is the rub between traditional Second Amendment rights and what they think it should be. When there's guys just coming into your house shooting at you, at a certain point you're gonna shoot back if you're armed.
Yeah.
Yeah, and so then they had to sit there for like a month with his dead wife and his dead son because his son was killed in the first the first encounter.
I think it was like 11 days, but still, yeah.
Yeah.
I think Waco was like the 6-week one.
Yeah.
And
so
that's similar to Waco in many ways. They had this warrant to serve David Koresh with, and it was based on how that whole incident really started was that the ATF was getting some bad press. There was these violations going on that people were mad about. And then they were kind of looking maybe for something to help. This is the story goes. They're looking for some way to help their kind of public image. The Branch Davidians were in the business. The Branch Davidians were buying wholesale weapons, ammunition, like tactical vest, and like the grenades that don't have any of the explosives in them anymore. Just people use them for paperweights and things like that. You can get them at Army Surplus Store. You can buy shot law rockets at Army Surplus Store, things like that. So there was a delivery that a post office worker dropped his box on the ground and busted open, and he or she saw a bunch of grenades. Called the authorities, and the authorities then tracked some of this stuff down, and they should have known that they were fake, that they were fake grenades, or they were not live grenades. And then the authorities, the ATF and whatnot, found some former members of the church who were basically disgruntled. They had left the church at some point, and they got those people to allege that there was some sort of child abuse going on. What the real story probably is that the Branch Davidians had a belief that David Krishna was divine. He was touched by God, and that the community would best be served by women bearing David's children. So some of the women would be married, but then would want to have sex with David and have his children. And there was some reports. There was some women that said things like, he was very sexy, he was very attractive, he was like a rock star, he was romantic. I wanted to have sex with him. So what I think that you probably this is me reading between the lines and reading a lot about this recently. I think that there was members of the church who left because they were mad that their wives wanted to have sex with David. And they did have sex with David. And they were like, this isn't for me anymore. They left. And then they would say whatever that they might say to the feds. At the end, what people need to realize is that while they were being slandered as a cult and abusing children, there was a kind of an extensive time where Child Protection Services was there, and they interviewed the kids, and they said they
Yeah,
all
I think they had a good relationship with Child Protective Services.
they did. The Child Protective Services reports were that these kids were well fed, well taken care of, well adjusted, loved. They liked David. David liked them. That they were like normal, and that they saw no signs of abuse, no signs of physical abuse, sexual abuse, any sort of psychological abuse. So, although their beliefs might be weird, and maybe the idea of like all the women in the community just having sex with the main dude is kind of weird. At the end of the day, these people had sincerely held religious beliefs about the end times. They called that the members of the mainstream society, the Babylonians, they saw America as sort of this Babylon empire that was, crumbling, and this deeply evil and corrupt empire. And, that's what they believed. And at the end of the day, they got this warrant that was totally bullshit. I don't know how any. I mean, I've seen some warrants recently, and the stuff that some of these judges are signing off on, man, just it frankly disgusts me. There was really no probable cause. The probable cause that they said was that, well, maybe some kids were being abused, which isn't a federal issue. That would be a state thing. So they had no jurisdiction. If there was child abuse, that would have been up to the state to come in and deal with. And there was the possibility that they were manufacturing illegal weapons according to the 1934 National Firearms Act, which, they then basically still tried to go with, even in the rubble of Waco after the place was burned down and 70 some people were dead. There were some independent firearm experts brought in to look at everything, and they said, none of this looks illegally modified. During the shootouts that took place, there was no there was no indication that the ATF or FBI was being shot at with automatic weapons or anything of the sort that was illegal. So, at the end of the day, you said you had this raid on the compound. It was supposed to be essentially serving a warrant, they said, on one hand, but then there was all sorts of things like people were full tactical gear. There was an instance where on the day of the fire, what happened is they rolled these tanks in and fitted the tank can of things with CS gas and sprayed all these canisters of CS gas in there. And
they said that it was to just smoke them out.
Yeah, they're trying to smoke them out. And an interesting
it's
thing.
Very flammable gas, but they basically pumped so much in that it was, an equal concentration with
Like the air, yeah. And they said there was like over 30 kids that died, and they said we're trying to help the kids, so they pump in CS gas, knowing that the kids didn't have face masks, and knowing that the CS gas causes chemical burns, particularly on children. It's just a horrible story, man. And they say, oh, so we're trying to help you make sure you're safe, kids, so we burned you alive after hosing you down with CS gas. It's just fucked up. And yeah, man, I don't know what else to say about it other than it's fucked up and these laws are fucked up.
And it's just I look at it
for
as,
no crime.
hey,
there's no crime he
you
committed.
Expect?
There's no crime. The only crime that committed
when
was
you show up with the ATVs and in full tactical gear and start storming someone's house, and they're like, we legitimately didn't do anything wrong.
Yeah.
The conflict is going to ensue, and I think from our, the point very much earlier on, that the founders would be okay with it.
I think
that
so
the
too.
government has overstepped, and you are repelling tyranny.
I think so too, and I think it was nothing but naked tyranny. I think if you legally, not just I thought this was fucked up as a layman and as a lawyer, and I was reading through this and looking at the statements and see the official reports that came after, and seeing the warrants and what their so-called probable cause was. Man, it's just appalling, and and I it unfortunately contributes to a deep strain of distrust for government. Well, maybe it's a good thing that there's a deep distrust of government and authority in Americans. Basically, from the founding of the country all the way through the 90s, and really beyond now, you're seeing this sort of people being arrested out on paddle boats for not so they're like social distancing, right? They're in the middle. There's the dude in the middle of the fucking ocean got arrested on a paddle boat. There's people in ball fields in the middle of nowhere getting arrested. It's still pretty crazy. It's Bear, like Bear. Oh, so let me hit. Somebody just asked about castle doctrine. Let me do self-defense, stand your ground, castle, and like run it through in like 2 minutes.
Yeah.
Okay, so you have three things related to firearms. Well, they're actually related to defending yourself. So these laws, in theory, would exist if there was no firearms ever, and so you can replace the firearm with your rapier, your sword, your battle axe, your mace, your flail, your nunchucks, whatever your weapon of choice is from your favorite historical era, assuming that there was no, firearms made. Deadly force works like this. A person is justified in using deadly force, and deadly force doesn't mean they have to die necessarily, but it's like serious bodily injury and actions that are likely to bring about serious bodily injury, potentially death. If they reasonably believe that the person is threatening them, and such force is necessary to prevent their own death or serious bodily injury, or sometimes to like a close, your kid, your wife. I suppose you can use it as a passerby even. If I am walking down the street and see Paul getting beaten to death, and the only way for me to stop Paul from getting beaten to death is to use deadly force, that would probably be applicable. The difficulty is that it's like easier to realize when you're in grave danger than a third party is in grave danger. So there's that caveat that's going to be in there. Okay. So the idea is, if someone's trying to kill you, and you have to kill them or hurt them very badly to stop them, you can. It's called an affirmative defense, meaning it's not just like self-defense isn't presumed. If two people are in an altercation and one ends up dead, the presumption is kind of that the one that's living killed him, and you at some point essentially need to put on evidence, and the evidence might be testimony. If two people are in the middle of nowhere and one ends up dead, it could be testimony, and if it's believed, that you will be charges will be, well, you will have proven self-defense, and then it will negate the charge of at least murder. But what do you think, Paul? The important thing to impress upon people is that it's an affirmative defense. You have to.
It's very important because
it can't be used for property. It can't be.
No.
It has to be. You think, that you are. It's necessary, absolutely necessary, to prevent yourself from being seriously harmed or killed. Like that's the standard's high.
It is high, and it's important to remember that when you're putting on an affirmative defense, you're basically admitting to the crime they are accusing you of.
Yes, you're saying I killed them.
I did, in fact, kill this person,
but
I had a reason.
Yes. So, yeah, and it generally can't be something. It has to be You generally can't be the provoker. You can't like go fuck with somebody, attack them, jump back a foot, let them come at you, and then kill them, and then claim self-defense. Um, so, and it has to be something that is probably reasonably likely to bring about uh, imminent serious injury or death. So, like, you know, if a 9-year-old's coming at you with a wiffle ball bat, uh, man, that's going to be a hard sell. You know, if somebody way smaller than you, very weak, somebody rolling up to you in a wheelchair, is coming up to you with a wiffle ball bat. You know, you can imagine these different scenarios where, you know, it's going to be a hard sell. You know, if you're like, you know, if you're like 6'5", 250 pounds and jacked out of your mind and on so much horse steroids that like you can't sit still for a minute, and then you try to say that like a 4'9" Filipino that was anorexic is going to kill you with his bare hands, it's probably going to sit in prison for a long time, man. So that is important to impress upon people. So that's self-defense that applies. Some states, well, even within self-defense doctrine, there's generally it's gonna depend a little bit state to state, but there's this idea of a duty to retreat, and that's a holdover from common law and back in England. And the idea here is that if you have the ability to get away safely, you should do that. That even though somebody might be threatening you seriously, if you have a way out to get out of the situation without killing them, you need to take that. Like, you have a legal duty to take that way out instead of killing them. That's the idea of a duty to retreat within self-defense.
Yeah, and then that's what brings in your
stand
castle doctrine for your home.
And stand your ground.
And stand your ground.
Let's do stand your ground first. Basically, just in real simple terms, it's going to depend jurisdiction to jurisdiction. But the basic idea is that duty to retreat is removed. It's, you know, line in the sand, not one step back, that sort of thing. So it's like somebody's threatening you with serious bodily harm or any self-defense, like, because there's self-defense you can raise for like a battery. So it doesn't, if you don't kill somebody but you just like break somebody's nose, you could still say I needed to defend myself. But stand your ground is generally just deadly force applicable. So you're not going to be able to say like, this dude was going to punch me in the face, so I punched him first, broke his nose, but I didn't have a duty to retreat. Like, if you could generally just get out of the place and they're not confining you in some way, you need to do that. So the stand your ground removes that in these life-threatening situations. It doesn't put an additional burden on your self-defense case. You basically don't have to go anywhere. You can be out in public, you can be anywhere, and not have to retreat.
Your personal space becomes your castle.
Your personal space, yes.
It's a very simplified way to say it, but...
Yeah. Like, this is my little... If you might have seen the South Park episode where he's like, this is my bubble. It was after the Trayvon Martin thing they were making fun of. The Trayvon Martin thing actually didn't ever implicate stand your ground. A lot of people thought it did. It was bad legal reporting. But still, like George Zimmerman didn't have the opportunity or ability to retreat because he was on his back getting his head bashed into the concrete. So, like, even if he wanted to, in theory, everybody pretty much... conceded that, well, how was I going to retreat? He couldn't get this dude off. He was like fighting, trying to get Trayvon out and couldn't. So, castle doctrine is basically a stand your ground in your house. What do you think? Is that the best way to describe it?
Yeah, I would say so. It eliminates that duty to retreat in situations.
Because if you don't have a castle...
the duty to retreat is usually like, there's a guy 10 feet from me with a knife.
Yeah.
Well, I'm reasonably in shape. I can run away, get to somewhere that can help me. Something like that. In this situation, it just says, well, this guy's got a knife. He wants to hurt me, even though he's over there and I can go run away. I don't have to.
Yeah. So
It's a. I also think there's some level of crime deterrence built into it, into the mentality, where it's like,
sure.
because it doesn't encourage crime. That the running away kind of encourages crime, because it's like, oh, that one got away, but I'm still fine, so I'll go for the old lady next time.
Yeah.
In this situation, it's kind of at your own risk. Like, just don't do it.
So if there's a castle doctrine, basically, and a lot of states have them, you just have to look up your own state. You don't have, you have to look it up because this is the general statement of law. You have to look up specifics to what state you're in because it's a state by state thing. Generally, if you're in your house, you don't have a duty to like run out of your house. You can, but what castle doctrine? Let's see, what's the big?
There's got to be a genuine fear. It can't just be for property.
Yeah,
if you walk in your house seeing a guy
yes
walking out with your TV,
you have to let him take the TV.
You can't just kill them. It has to be some kind of actual threat to you or the members of the household.
Yeah, so that's the thing that some people, I think there's at least a common enough misconception about castle doctrine that it's like the old style of this house is my castle. Anybody that comes in here, I'm the king and I can execute them. That's not what it is. It's way less than that. It's basically saying you don't have the duty to retreat in your own home. If you have a duty to retreat in generally outside in where your state is, and some might have a civil liability aspect in some of these laws. Again, it's going to be state to state. Where if you're found that you used self-defense justifiably in your house, the family of the deceased can't then like sue you for a wrongful death under some other claim. That it'll bar that. So yeah, it's not about just killing anybody that comes into your house or protecting material goods. That's generally in most places. There might be an old Texas law that differs from this general standard, but the general standard.
I think Texas is a little different. But
yeah, I think Texas had some old laws that are still in the books that are funny. But the general idea is that if someone's in your house trying to kill you, you can kill them without a duty to retreat. If you really they're really trying to kill you, if it looks like a simple breaking and entering and they didn't know you were home and they're trying to run away and you shoot them, you're probably going to go to prison for murder. If someone's in your house, but they, here's the scenario. You're sitting there chilling, watching the Rich and Paul live stream, and somebody comes in and all the lights are off and you're there in your hoodie with your Glock and you look over and he sees your big white eyeballs and he's like, oh shit, and he starts running out the door. You can't, and then you grab your gun and you can't shoot him. Castle doctrine doesn't matter. The dude's getting the hell out of there. He's basically just a trespasser at that point, and trespass to property isn't going to be any way that you can say, I think he's going to kill me. Like, that's going to be a real hard sale. So I guess that's self-defense, stand your ground, castle doctrine. I think there's some misconceptions there. They all weave in and out of each other a little bit, and just look it up to your state. And if you have questions of what the statute is, you can reach out to me and I'll break down the statute a bit for you But some extend to your vehicle that you're in. You don't necessarily you won't have a duty. Some of them are real simple. It's like there's a no duty to retreat in your home, duty to retreat in generally in public. That's like I'm looking at Nebraska here. And yeah, some of them are much more complicated. Some of them are pretty simple. It just really depends where you are. And like I said, this is all dependent on you actually believing you're in for serious bodily injury or death, and it being reasonable. You can't like be having a psychotic episode where you think like a 90-pound anorexic person with a wiffle bat is killing you, like, and you say, well, I really believed it, like I really believed that they were going to, like, it's not going to, it's probably not going to be a good sale, man.
Yeah.
If this happens, if any of this happens, somebody asked me about what do you do.
Hey, Rich.
Yeah.
Before you get into that, I'm gonna jump off here. Let you
All right, man, you got anything,
finish up with them.
anything you want
no,
to say?
just thanks everyone for a good stream. Thanks for having me on. We'll do it again. Sorry, my schedule conflicted a little bit here and had to jump off before we totally finished. But
all right, man, it's
good
a
stream,
good,
everyone.
it's a good show. Appreciate it. Thanks, man.
Yep.
Talk to you soon.
I will. Yeah, I'll talk to you soon.
Oh yeah, if something like this happens, if you have, no, losing property isn't going to fall under life threatening. You can use reasonable force to reclaim chattel property, but it's like it's a real low bar. You can't really even hurt the. You can't like cause a serious injury. The other thing is, like, if something like this happens, you're going to want a lawyer. I've told people I'm close to in real life, give me a call. Don't say anything until I get there. It's generally, if you end up in one of these situations, the police are definitely going to take your gun. You're probably going to spend a night in jail until they sort things out. Don't start blabbing. You're going to have crazy adrenaline for like 2 days. You're probably not going to be able to sleep. You'll probably be shaking. You might have PTSD. You need therapy. Definitely going to take your gun as evidence. Doesn't mean you did anything wrong. It's procedure. Like I said, they're probably going to at least put you in the back of the cop car when they get there and you're there with your gun and person's dead. I wouldn't have the gun on you still if it happens. I would put it like, I would take out the magazine, clear the chamber, set it on a table somewhere, put it in a drawer. You can direct them to, hey, there's a drawer in the kitchen. Some of the advice I've seen is to call, if you have to call the police, you say there's been a shooting. Please send an ambulance and police. And then when they get there, to not say anything else till you have a lawyer. And, maybe it might be something to talk to with a spouse about, or say, hey, if this happens, I need you to call this lawyer and tell me not to say anything. One of us needs to be cool. It's going to be hard to be cool, man. Situations are stressful. Like I said, man, you're going to have a big adrenaline dump. You're going to be like nervous. You're going to be like, what the fuck? The police may or may not be cool. The police may come and be like, yeah, this look, they see a broken window. They see a struggle. Dude had a knife or a gun. You might be injured. It looks, obvious what happened. You might be in a situation where it doesn't look so obvious as to what happened, You're going to want to not talk to the cops, like Hillbilly Joker said. You're going to want to wait for a lawyer. You're going to want to get a lawyer soon to help you out with just to be the liaison anyway. Just to make sure you don't say anything stupid. You don't accidentally say, you can't lie to federal enforcement agents at all. Local cops a little different, but you still, depending on where you are, it could be an issue. It's a very serious thing, and anybody that carries a firearm regularly should think about it. They should think in their head, like, what's going to happen if I ever have to shoot somebody? If you carry one, man, that's the kind of the terminal issue that could happen. You want to have your plan, like, run it over in your mind. They're like, okay, I got in this bad situation. I had to had to shoot somebody to defend myself. My life was on the line. Like, you know, tell your wife, girlfriend, parents, like, here's a lawyer I want you to call. I want you to tell him, come help me out. Yeah, I think there's some places that sell like an insurance that you can call, and they work like a you know, I don't know the ins and outs of them, but from what I understand, so you're going to, like, I can't really give you much advice on carry insurance or anything. I just don't know enough about them. But from what I understand, it's like they, you know, they pool money to have lawyers kind of ready to go for something like this. They might give you a card. You know, like some places give out cards, and it's like, if you were in a shooting, here's what you do: call 911. You know, they might be a little script, and maybe you could look those up. Maybe I'll think about making one. Maybe, I'm sure there's already really good stuff out there. And it might say, like, you know, be calm, empty your pistol, put it in a secure location, call 911, tell them there's been a shooting, tell them you need an ambulance and a police, and give them the address, and hang up. Call your girlfriend, boyfriend, husband, wife, mom, dad, pastor. Tell them I need a lawyer. There's been a shooting. I'm okay, but I need a lawyer. Police are gonna come. You're gonna say, hey, I need a lawyer. I would like to talk to a lawyer. I want them to help me out with this. The police may be super cool, and they might be like, look, man, I think you did the right thing. I just want to help you out and get this cleared up. And they're just trying to do their job. Like, and I know people say that a lot, and it's bullshit. But let's just, again, kind of let's suspend some disbelief. And let's just say that the cop really is on your side, and he really does want to help you out, right? The issue is there might be a rogue prosecutor that takes something you say to the cop and, you know, goes crazy with it. So, like, even if the cop is a good dude, the cop could be like your brother-in-law, right? But, like, if you say something and it's not going to be a privileged communication, and the prosecutor gets a hold of it, man, you just open up a bag of worms.